Bismillah.
Assalamu alaikum wa rahmatullahi wa barakatuhu. Alhamdulillah rabbil alameen. As-salatu wassalamu ala rasulullah sallallahu alayhi wa sallam. A'udhu billahi minash shaitanir rajeem. Bismillahir rahmanir rahim. First off, I would like to thank all of you who have joined us today. Alhamdulillah, we see we have over 40 participants and more are joining. I, along with the program committee, have been planning this seminar for quite some time now, so we're very pleased that it is finally taking place. One thing we know for certain in this life is that one day it will end for all of us. We know this because Allah subhanahu wa ta'ala says in the Quran in multiple surahs, Kullu nafsin dha'iqatul maut, every soul shall taste death. And we also know through our experiences of losing our loved ones that death can come at any time, whether we are young or old, with or without any warning. Allah subhanahu wa ta'ala gives and he takes life at a time that only he knows. And whenever we end our life and start the next one, the everlasting hereafter, an important matter that we should have all taken care of is ensuring that our inheritance is prepared to be distributed accordingly. Allah subhanahu wa ta'ala has laid out the conditions and guidelines for this in the Quran, and it is also essential for the family of the deceased to ensure that the inheritance is calculated and distributed properly when the situation arises. Allah subhanahu wa ta'ala has commanded us to comply with this also in the Quran. For this reason, we have set up this very important seminar in which Maulana Javed, who we are all blessed with to have as our local scholar, guide, and educational director at ICCL, will lay out the importance and the rules of inheritance as we should know them. Also, for many years, community members have been asking us how to set up their inheritance properly, whether it be in the form of a will or a trust, and who to go to for that. We are very pleased to have Brother Damani Ingram, who is a lawyer based out of Columbia, Maryland, here with us today. Brother Damani and his firm create and execute Islamic wills for Muslim clients. Today, he will be going over the methods of getting this set up for you, inshallah, and also inform you what services are available. We ask that you please allow Maulana Javed and Brother Damani to educate us in this matter, and that towards the end of this program, we will open up the floor for a question and answer discussion for all. So at this time, I would like to request Maulana Javed to please take over and begin the seminar.
Alhamdulillah wa kafa wassalatu wassalamu ala ibadihi alladhina istafa. Amma ba'd, fa'udhu billahi minash shaitanir rajim. Bismillahir rahmanir rahim. Qala Allah ta'ala, innal ladhina ya'kuluna amwala al-yatama dhulman innama ya'kuluna fi butunihim nara wa sayaslawna sa'ira. Amma ba'd, all praise be to Allah subhanahu wa ta'ala, the most magnificent, the most beneficent, the most merciful. All praise be to Allah subhanahu wa ta'ala for all his ni'mah and favors that he has bestowed upon us. All praise be to Allah subhanahu wa ta'ala for giving us the divine guidance, the tawfiq, and the life to be present on this broadcast today. The topic of discussion, as you all know, is the topic of inheritance, and that's what we're going to be talking about, inshallah. And we will, in the time that we have, we won't be able to go over every aspect of inheritance and every aspect of Islamic law in regards to it, because situations differ and they're relative to each family, they're different to each family, and the shares differ from family to family also. So obviously, there is going to be certain things that are only applicable to certain families and certain things that are not applicable to certain families. So if you keep hold of your, I know you're going to have questions, you can hold them right till the end, inshallah. But what we want to do is go over some of the basics of ilmul fara'id. It's called, this science is called ilmul fara'id. Fara'id is the plural of farida, which literally means that which has fixed and determined. Since the Quran has fixed the shares of the different heirs in the estate of the person who's making the will, who's making the deceased's estate, this branch of knowledge is called fara'id. And the importance of it has been emphasized by the Messenger of Allah sallallahu alaihi wasallam. And in one of the hadith of the Prophet sallallahu alaihi wasallam, the Prophet sallallahu alaihi wasallam said that, and he exhorted the acquisition of teaching ilm al-fara'id. And in this regard, he said that I shall be taken away. Learn fara'id. Fara'id here means the laws of inheritance, and teach it to others, and teach it. The time is near for the door of wahi to be closed. The time for the disappearance of knowledge will dawn when two persons will dispute regarding a necessary question or some jurisprudence, and they will find no one to decide the dispute, meaning that there will come a time when there will be a lack of knowledge. Similarly, the Prophet ﷺ said, in view of the importance and the significance of inheritance, he said that its knowledge is described as half of knowledge itself. That's how important it is. And Umar radiallahu anh, he used to say, "Oh people, learn fara'id with the same concern and effort with which you learn Quran." And nowadays we find that ilmul fara'id, the knowledge, the knowledge in regards to inheritance, is discarded. Actually, it's not even paid any, there's no importance to it, because maybe some people feel that they are in better advantage of acquiring certain assets after the death of the father, or because they're in a position of power and authority and in control. But despite all that, Allah subhanahu wa ta'ala has given certain rules and regulations in regards to it. When a person has the right to, in his own wealth, as far as his life until he is alive. Even when he is alive, that wealth, according to Islamic law, is an amana, is a trust that is given to him, that he utilizes by the will of Allah subhanahu wa ta'ala. After his death, everything is distributed according to Islamic law, and a person doesn't have the right to actually change that, or to actually to curtail anybody's rights. When a man is writing his last will and testament, sometimes some abuses and violations that happen is that they delete an heir, and because either that heir is disobedient or whatever the reason, personal reasons, and to unnecessarily to delete an heir without any reason, without any Islamic reason, that is an abuse and violation. That is an abuse and violation of the rights of the heirs itself. The number two, it could be by reduction of fixed shares. Somebody can reduce the fixed shares that Allah subhanahu wa ta'ala has already determined in Sharia, and he tampers with these fixed shares, so that is also not permissible. Or by imposing of an un-Islamic restriction, for example, that the estate the winding up of the estate be prolonged for a certain amount of years, and that is a restriction that is un-Islamic restriction for no reason that is happening. Or defining the age of adulthood as not as defined by maybe secular law, or not, and not defined by Islamic law. Discriminating in the assets of the estate itself. Some people discriminate in the assets of their estates. Part of the estate is bequeathed to an heir, while the remainder is subjected to the Sharia laws of inheritance. That is discriminating in the assets of the estate itself. Or by introducing non-heirs into the distribution, that also is not permissible. For example, give you an example of a non-heir is when the father passed away, the son had already passed away, meaning the son was not alive when the father passed away. So the son's children will not inherit. The son's children will not inherit. There will not be the direct inheritors. There will not be the direct heirs. So but he includes the son, his grandchildren whose father has passed away, and he includes them in the inheritance. So that is introduction of non-heirs into the distribution. By the way, Sharia gives leeway. Sharia gives the possibility of even bequeathing a part of your inheritance to non-heirs because you wish to do so, but there is a way on how to, there's a way and a manner in which it needs to be done. Or by bequeathing more than 1/3 to an outsider. An outsider means a person who's not a direct heir, and you bequeath, a person bequeaths more than the amount that is more than 1/3 of his wealth. So, or also by the denial of the rights of the creditors. Nowadays, we have people are hiding behind corporations, LLCs, so that they can the debt that is incurred that does not inherit is not inherited by the heirs, but just hiding behind that might save us from the local laws, but that doesn't save you from Islamic law. If a debt is owed, it's owed. If you owe money, then you owe money. Hiding behind a corporation is not going to benefit you. So that is some of the ways of some abuses and violations. I've just mentioned that it's not limited to what I have said. It goes beyond that. And it's unique. Mirath is not up to one's discretion. Mirath means the inheritance is not up to an act which has been assigned to, like, if you wish to do so, you may. If you do not wish to do so, you don't have to. No, it's this inheritance is a right which is transferred. It is confirmed for the heirs without the directive of the person making the will. So, for example, if one person was to die, irrespective if there was directive or not, it is the right of the inheritors that they inherit from him, because it's a divine right. It's a God-given right. And if for some reason or another a person does not wish to be the heir, he doesn't wish to be somebody's heir, his wish is of no significance. His wish has zero significance. The moment the person passes away, automatically the right of inheritance is transferred, and right of ownership in the assets is transferred Islamically into the heirs, irrespective of if he wishes to reject it or not, Islamically. So obviously there's, we have the secular law where a person can say, well, I don't want anything, and that's different. But Islamically, he would still be the heir, to such an extent that if a person refuses his share of inheritance, that the qadi of the time, the judge, could actually compel the estate, the assets to be delivered into his possession and to be delivered into his custody, even if the other person doesn't wish them to. What he does after that point is up to him. But to take possession is also an important part. And sometimes this is, again, where some people might get together, or some heirs might get together, and one brother says, listen, Allah has given me plenty, I don't want it. The right way to do that would be to receive this, to become the recipient of the share, and then whatever you want to do with that share after that is up to you. But to receive it is also incumbent upon you as far as Islamic law is concerned. If sometimes we find that there is a will that might be un-Islamic, so what do we do in that situation? In that situation, in an un-Islamic will, what we will do is we will make sure that the will is actually executed according to Islamic law, with the agreement of the heirs, because obviously you would need the heirs to agree on that. But again, the law of the land will still execute that un-Islamic will, because that's how it's been stipulated and written. So it would still be the duty of the heirs to correct it, and the shares, because they have already been determined by the Quran, and Allah subhanahu wa ta'ala didn't even leave it in the Sunnah of the Prophet sallallahu alaihi wasallam. Somebody might say, oh, it's in the Hadith, it's not mentioned in the Quran. It's this, the laws are, it's been clearly stated in the Quran. All the shares are very clearly stipulated in the Quran. So there's no ambiguity as far as that is concerned. So it still would still be, the heirs would still be duty bound, irrespective if the will is an Islamic, that they get together and come up with a solution to make sure that it abides by Islamic law. There's a hadith of the Prophet ﷺ, and it's very important, because a man lives his life according to the dictates of the Quran and Sunnah, and he comes to the end of his life and he makes a will that is against the Quran and the Sunnah of the Prophet ﷺ, thus by entering into the fire of Jahannam. And Allah subhanahu wa ta'ala mentions in the Quran after the verses of inheritance, وَمَنْ يَعْصِ اللَّهَ وَرَسُولَهُ, whoever disobeys Allah and His Messenger, وَيَتَعَدَّ حُدُودَهُ, and he crosses the limits that Allah subhanahu wa ta'ala has set forth, يُدْخِلْهُ نَارًا, Allah will make him enter into the fire, خَالِدًا فِيهَا, in which he will live there for eternity, and he will have a very humiliating punishment. Allahumma hafazna minhu. Allah subhanahu wa ta'ala save us all from that we exceed the limits as far as the inheritance is concerned and Islamic wills are concerned. Sometimes a person might be compelled in the sense that he has children who are drug addicts, he has children who are alcoholics, he has that he needs to dispose of his estate in his lifetime. If he needs to dispose of his assets in his lifetime, it will not be inheritance, it will be a gift. And as far as gifts are concerned, they have to be of equal value to each person, to each heir. So for example, if a brother and sister, in a normal situation, the brother would be eligible for double the share of the sister. But in the lifetime of the father wishes to distribute the assets will be distributed equally. The assets will be distributed equally in the lifetime, if it's distributed in the lifetime. And then there could be many reasons as to why he wants to do that. Sometimes there are situations that come to us that the father fears that, no, Allah forbid, my son's an alcoholic, my son's into drugs. If he was to inherit, he is going to destroy everything. So what he does is, those children of his that might be trustworthy, he distributes the assets equally, but then he puts that one son's share in a trust that is safeguarded until a time where he's able to kick the habit, or he brings himself around to actually make some amends in his lifetime. That these are just some of the reasons a person might want to dispose of his assets during his lifetime. Disposing of one's assets also means that it also leaves his ownership and goes into somebody else's ownership, and that's a risk that he could take. And this is whether Brother Damanishur would come in, and this is why we have him online with us today, is because I would advise anybody who has assets to have a living trust, so that the continuation and the trustees would change going forward, and everything else remains with the trust. And if you have a living trust, you could safeguard all of your wealth, and you would also save yourself a whole load of taxes. But I'll leave all that to Brother Damani to explain, inshallah. Now, some wealth which is excluded from inheritance. If I'm going a bit too fast, do let me know. Some wealth which is excluded from inheritance, and this is important. Number one, any wealth which has been acquired by haram means, for example, gambling, prostitution, bribery, misappropriation, theft, interest, any wealth that has been attained through haram means, such wealth does not enter into a man's ownership. So for example, even if a man acquired it, Islamic law, we're discussing Islamic law. according to Islamic law, if somebody acquired haram wealth, it doesn't enter into his ownership. If it never entered into his ownership, then it would never be subject to the laws of inheritance. It would not form part of his estate, even though in the other law, in the local laws might be different, but Islamic law, this is what Islamic law states, that haram wealth, and I gave you some examples of haram wealth. And again, if you want further elaboration, you can ask me later, or you can ask me privately as to what constitutes haram wealth. Now, if a person, for example, I borrowed something from Mr. X, or I took something from Mr. X, and when I passed away, that commodity or that thing would not form part of my estate. It would not form part of my inheritance. It would need to be returned back to its rightful owner, if the rightful owner is alive. If the rightful owner is not alive, it would need to be given to his heirs. And if the rightful and if the heirs cannot be found or located, that wealth has to be given in charity to the poor Muslims and to those who are needy, but it cannot, for under any circumstance, form part of the estate. And that includes money that might have been attained through gambling, or might have been attained through a lottery ticket that somebody might have won. And you might be surprised, there are Muslims who do, come buy some lottery tickets with significant amount of money, and they don't know what to do with it. And when we tell them that they cannot benefit from it, obviously it's difficult when they have to part with thousands and thousands of dollars. If an asset is pledged as security for a debt, so if I had a house and I pledged that as a security for a debt, and if there are insufficient funds in the estate to release the pledged asset, so I'll give you an example. So we can understand it better. I had a house. I pledged it to buy another house, or is pledged against another loaned amount. The heirs can either pay the pledged amount and release the pledged security, but as long as it's pledged, it will not form part of the estate. Number 3, this is where I'm sure that a lot of people might have some questions. If number 1 didn't raise any questions, number 3 possibly will. Insurance and endowment policies that are based on riba, with contracts which are haram to enter into from the get-go. A person is only entitled to the premiums paid by the deceased, which forms part of his inheritance. For example, if somebody had a life insurance policy, and over the years I paid $10,000 towards that policy, $10,000 would form part of the estate. The other dividends that we will get after this person has passed away, that will not constitute part of the estate. It will not become part of the estate. So a person should be very, very careful as to what is coming into his estate and what is distributed as part of his estate. It needs to be defined. It's important. Because you don't want haram funds to be distributed and other people utilizing it because you put in a haram policy in place. Sometimes a person might be given a pension fund that is being government funded, or he's not really paid into it. It's been given to him by his workplace. The pension fund, if the possession of the pension fund is done, so if a person is, let's say hypothetically 80 years old, and when he was 75, he received he cashed it out, and he got a dividend. He got $50,000 or $100,000 or in return. Then if he took possession of that pension fund in his lifetime, it will form part of his estate. If he didn't take possession of that pension fund in his lifetime, then whoever is the beneficiary of that fund after the person's death will be the owner of such funds. It doesn't it doesn't become part of the estate. Again, my job is to highlight Islamic law. Brother Daman is, he's going to come and clear out all the creases that I'm going to be creating for you in your minds, because obviously this is going to cause some issues. So this is what Islamic law states. Rights. If a person has a right in a business, for example, I own 50% interest in a business. If one of the business partners passes away, the heirs do not become automatic partners in the business according to Islamic law. They do not become partners in the business. That doesn't mean they lose their right in the business. Their rights will remain according to the share, and it will be up to the business partners to actually pay out the inheritors and give them their share. But the partnership doesn't automatically transfer to the heirs, and unless stipulated in the contract that was already written between yourselves and the business partners that you entered into business with. If a person has entered into a lease, or he has lease contracts, then according to Islamic law, the leases will automatically lapse with his death if a person passes away, and unless again stipulated in some contract between the person that he's leased his house out to, or what his business is out to. There are other things. If something is borrowed, from somebody, I borrowed your car, I borrowed your lawnmower, whatever that is. If something is borrowed, it has to be immediate. That it will not form part of the inheritance. It will not form part of the estate. It needs to be returned to its rightful owners. And there are other things, but I'm not going to go into them. But again, because they are relative to each person and each family, it is you may ask me inshallah later. Now there's sometimes and this happens a lot. So a person in his home, he says, okay, this is the money that I put aside for Hajj. This is the money that I put aside to give to ICCL or MID or whatever institute that you want to give it to. And this is the money I've set aside for the needy. But what you didn't do is actually, it's still in your cabinet and it's set aside, but it was never distributed. If that money has been set aside, it will form part of the estate, and it will be distributed in the main. So if you want certain contributions to happen, it needs to happen in your lifetime. If just money set aside in your wardrobe or underneath your pillow or underneath your bed is not good enough, if any money is found, nobody it will form part of the main estate, unless obviously there's some witness and some proof, and the proofs and all the heirs agree that it should be the money set aside should be used as it was set aside by the person who passed away, then it could happen. But according to law, it would still form part of the estate. Similarly, if a person has put money aside for zakat is obligatory, right? It's fard. But again, because it was just set aside, it was not removed from his possession, it was not removed from his ownership, it will still form part of his estate. So when a person passes away, there is the burial expenses, which will come out of his estate. Again, there is details in that. It cannot be lavish, it cannot be extravagant, it only needs to be what that is according to the Quran and the Sunnah of the Prophet sallallahu alaihi wasallam. If a person wishes to, if you want to have a lavish burial, and one of the heirs, once that the heir can pay for it, but it will not come out of the estate. Debts, obviously all debts, and debts are of different kinds. I'm going to come to it. And there's also then the third part is wasiyah, and any bequests that one makes. A wasiyah is made in 1/3 of a man's inheritance. Wasiyah is made. So three things will come out: burial expenses, debts, and anything that a person has bequeathed, and that bequeathment is in 1/3 of his estate. And I've just mentioned to you that the burial expenses should be according to the Quran and Sunnah. It should not be that I should be relocated to another country and all the money is coming out of his estate. And that's not technically Islamically permissible, but I'm sure that it would be okay by the law of the land, but it would not be Islamically permissible to spend an extravagant amount of money on the burial. It should be according to the Quran and Sunnah of the Prophet ﷺ. Now, when you come to debt, which is the second thing that will be taken care of and we will be satisfied, it's important to understand that there are three types of debts. And if you understand these three types of debts, then we can just go into wasiyah after that. Number one, which is the most important type of debt, such a debt that is confirmed by a statement made before a person goes on to the sickness that took his life, meaning the moments before his death, that sickness which made him bedridden and he never recovered from. So all of those debts that were incurred prior to that time are categorized as Class A debts. A Class A debt is confirmed by a statement, it's confirmed by witnesses, or there's testimony of witnesses that is present, and it is common knowledge. It's also common knowledge that these debts debt is classified as a Class A debt. The Class A debt takes preference over all debts. A Class A debt will take preference over all debts because there's statements, there's witnesses, there's testimony, it's common knowledge, and the deceased had openly spoken about them. So Class A debts. And then there's Class 2 debts, Class B debts, which are only confirmed by a statement made by the person who's passing away on his deathbed. So statements of debt made on the deathbed and outside and before that is there's a clear distinction between the two. And when a person dies, we need to classify what type of, does he have a Class A debt, does he have a Class B debt, or does he have a Class C debt, which is the third category of debt, which is he has outstanding zakat, he has outstanding sadaqatul fitr, he has unfulfilled sacrifices, qurbani, that he needs to do. There is unfulfilled kafara that needs to be paid. There's fidya of fasting and of prayer that needs to be done. If these that is a Class C debt, and the Class C debt could also, if a person had made wasiyah of them, it could also be satisfied by 1/3 of his estate, as long as they do not exceed 1/3. If they exceed 1/3, by right they will not be fulfilled. They may be fulfilled with a meeting of the heirs. Now, when we're talking about heirs here, and when we're talking about the heirs giving permission to do so, we're talking about heirs that have reached the age of puberty. When we are dealing with heirs that are not reached the age of puberty, it becomes even more difficult, because to get for a child to admit to paying a debt would not work. It would not be. It will not satisfy the debt because they have not reached the age of puberty. So what they'll have to do is either the heirs themselves pay from their shares, but the child's share will not be touched because the child is not of an age to give permission and to give consent to pay that debt. So again, there is again a certain detail into Class A debts. There's some detail into Class B debts, and there's some detail into Class C debts. Again, if we try to go over all the details, it's going to obviously take a lot of time. But I just want you to know that there's Class A debts, there's Class B debts, and there's Class C debts, and each one can be satisfied as long as the person has there are certain rules and regulations stipulated in regards to them. For example, if the Class A, if a person owes $12,000 and his estate is worth $12,000, and the person that is entities, and if a person owes way beyond the $12,000, way beyond his estate, and the Class A debts, we will satisfy the Class A debts first, and then the Class B debts. So remember how important it is that if a person has debt, that he actually write it down. Otherwise, they won't be classified as Class A debts. Even if he remembered them at the time of death, it won't necessarily be stipulated as and written down as a Class A debt. There is obviously advice to creditors themselves that obviously there is great reward in charity, and one of the greatest charities is to and highest forms of charities is to forgive a debt and waive part of a debt, or grant extension of time to the debtors if any of the above options is not affordable. Now, there is certain detail in regards to the Maradul Maut. The Maradul Maut, as I mentioned before, is that a man is free to act and operate in the bounties of wealth that Allah subhanahu wa ta'ala has provided to him whilst he's sound and healthy. However, when a man approaches the last stage in his earthly life, and he's hovering between life and death, the Sharia curtails his former freedom of disposing of his estate, and at this stage the rights of the heirs in his estate are activated. Even before his death, they're activated in the sense that he is not able to do freely what he wishes to do with his wealth if he dies in that state. Obviously, we don't know if any sickness is going to be his sickness that takes him to death unless he actually dies. So the sickness that takes his life will only be defined after his death, because to define it before that, we wouldn't know. And then there is detailed explanation as to what a person can do and what a person can bequeath at the when he is in the last. There are certain things that he can still do at the time in his sickness that takes his life. He can still do that, and it can still be executed. But again, there's details and there's a masail in regards to it as to what he can do and what he cannot do. Let me give you one example, and I'll go to the next topic. It says if during the last stages of a man's life, he acknowledges certain rights and obligations, which is common knowledge, or it's also evidenced by witnesses, then such an acknowledgement will be fully valid, and it will be discharged, and its discharge will be just as incumbent as those obligations that were classified as Class A debts. So not everything that a person does at the time when in the sickness that takes his life is invalid, but certain things are quite valid and some things are invalid, and a person needs to we need to be aware of these things because it's important, because we shouldn't leave things to the this teaches us a lesson that we can't leave things to the last minute and to the last second. And now that we know that we're going to die, we suddenly start distributing our assets. Or now that we know that we're going to die, we start making certain contributions. Now that we know that we're going to die, we start making certain contributions that might deprive the heirs of their rights. Again, it could be variations of things that can happen, and each one, the rules and regulations in regards to them are quite clear. And again, we just don't have the bandwidth to go into each one in detail, but it's important for us to note that some things will be valid, some things will not be valid. So going to the third part, so a person's burial expenses will be done, a person's debts will be taken care of, and we've classified the debts. And then the last part, wasiyah. Wasiyah is a bequest made by a person for a part of his wealth to be contributed after his death to a person or institution, and that is called, in the terms of Sharia, wasiyah. And wasiyah, it can be made in 1/3 of one's assets, 1/3 of one's estate. Some certain things which will form his wasiyah will be contributions made during his sickness of death, gifts, he waived certain debt that was due upon him, certain acts of charity will form 1/3 of his will become his wasiyah now. And so inheritance is the heirs, and the inheritance part is already been decided by Allah, but the wasiyah part, a person has some kind of leeway as to what he wishes to do and what he doesn't wish to do. Again, if a person wants to give a certain amount of money or contribution to some kind of to an institution or a masjid, he may do so, even if that contribution is made, and that if it's made during his maradul maut, which it will form part of his wasiyah. Payment of fidya for the fasting, or for salat, or for hajj, which was not executed during his lifetime, it will also form part of his wasiyah. Hajj will be made from 1/3 of his wealth. And payment of kafara for violated oaths or fasts, etc., will also form part of his wasiyah. Again, there's much detail. There's many more, that if this happens, then this will happen. If this will happen, well, that will happen. There's quite a significant amount of detail as to what will form wasiyah. And it's also necessary it's also important that the person appoints somebody as somebody to execute his will, because and it becomes obligatory upon the person that has been assigned to execute it. He doesn't have the right to back out after the person has passed away. He does have the right to back out during that person's lifetime. There are certain things which are recommended that a person should make wasiyah of. There are certain things that are permissible. There are certain things that are wajib, meaning it is compulsory that a person make wasiyah of those things that are liabilities, such as trusts or articles of trust that he might have in his possession, or if he has, a certain amount due upon him due to fidya, salat, or zakat. These things are obligatory, and certain things are preferable, certain things are permissible. There are certain things which deprive heirs of inheritance. There are, the rules of revoking. A person can change his wasiyah in his lifetime. Obviously, it can't be changed after his death, and there has to be a clear indication that his wasiyah, that he has to say, I have revoked this wasiyah, or in writing that I am cancelling this wasiyah, I am or I have cancelled or revoked. There has to be some clear indication from him that he has revoked of or changed his wasiyah. Difference of religion, again, that's also many rules and regulations in regards to that. There are what Salah mentioned, what Shanta mentioned. I think I've already spoken for quite a bit. I have given you a brief synopsis as to what a person should be doing. There's one thing: what forms a person's estate? So you might be thinking that stocks, shares, liquid cash on hand, cash in the bank, business, business contracts that a person might have, or business affiliations, or businesses that he might own, or partnerships that he might be a party to. That is the obvious. But then there is the clothing, then there is those things that a dollar amount can't be put on: the food in the kitchen, the utensils in the kitchen, the silverware, the cookware, the chinaware, all of these things forms the part of one's inheritance. That's why there should be, between a husband and wife, there should be a very clear cut who owns what. There should be a very and sometimes there's such ambiguity that, oh, is this cooker owned by the husband or is this cooker owned by the wife? So make your mind up. I think it's very important, it's very important that there be clarity of ownership in everything that is in the household. For example, a man can just say, listen, the entire contents of this household is owned by my wife. Even though I might have bought it, I've gifted it to her. So there's no ambiguity for any. And then he says, any future things that we buy for this house is also the ownership of my wife. The only problem you'll have is if the wife dies before the husband. Now everything will form part of the estate, and a liquid amount, a dollar amount will be put on those assets. That doesn't necessarily mean that you have to get rid of them. Still, a dollar amount will be placed upon those assets, and they will still form part of the estate. So remember, what forms part of the estate in common law might be slightly different. What forms part of the estate in the Islamic law is everything does. So technically, everything, underline it, bold it, strike it through. Everything forms part of everything in your ownership is part of the estate. With this, inshallah, I will ask Brother Damani to actually come online and inshallah continue from this point onwards. We could go on with the Islamic rules and regulations, but we will take your questions inshallah afterwards. But Brother Damani, inshallah, over to you now, inshallah.
MashaAllah. Assalamu alaikum wa rahmatullah. Wassalatu wassalamu ala Rasulullah. Sheikh gave a very, very robust explanation of the components of the Islamic rulings and components of Islamic estate. What I have is something that can go over some of the basics of an Islamic will, what you have to look out for when you're actually going to put this down on paper, and ways to preserve it. And for those of us that are consulting attorneys or consulting organizations to help them put together their will, these are some of the things that you need to make sure that are contained in the will. I will plan to go over some of the differences between a will and a living trust, because that seems to be that's always been popular. A popular point of talk has been, should I have a will or I should have a living trust? What's the difference? What's most appropriate for me? I am going to attempt to share my screen, and hopefully we can see a slideshow. In a minute, let's see. Okay, because I assume, I'm hoping that folks can see this now. Can you see that, Sheikh?
Yeah.
Okay. So, and I'm not going to try to bore everybody too much, but we're going to just want to go with some of the basics. I think things that everyone needs, each person needs to have an idea of what to look for and look forward to when you're preparing your will and actually getting your estate together. So we know that as the Imam had told us, that it's extremely important that we have our estate to get together, that we have a will. We have one of the hadiths from the Prophet sallallahu alaihi wasallam who mentioned that it's not rightful for a Muslim person, if he has anything to bequeath, that he sleeps 2 consecutive nights without having his will with him. So we know that we don't know when we're going to pass away. Many of us may not even be fortunate enough to know if we are knocking on death's door through illness. So that means this is something that has to be done and considered immediately. Looking at some of the ayahs from the Quran that encourage us to begin considering what's important when it comes to distribution of our assets. And I will attempt to read this part of this ayat, which is in Surah Al-Baqarah. A'udhu billahi minash shaitanir rajim. Bismillahir rahmanir rahim. If I can clear this out. We have the portion here, if we look at the English translation, it is prescribed for you that when death approaches any of you, if they leave something of value or anything of value, a will should be made in favor of parents and immediate family with fairness. This is an obligation on those who are mindful. This is an obligation. This is something that we cannot, of course, sidestep. I have a lot of clients that come to see me, and some folks feel that once they start getting their wills together, that means death is going to approach them sooner. We know that as Muslims, that's not going to happen, but it's important that we take this command very seriously. Additionally, we look at about the definitions of a will. What is exactly a will? Some folks think that a living will is a will. A living will is not a will. A living will does something totally different than what a last will and testament will do. The living will, we have the English definition of it, which defines it as a written document that leaves the estate of the person or the person who signed it. And let me, I need to move this quickly. But we have the person who signed the will and named certain persons and entities, beneficiaries. This is what it is. It has to be written. Now, we do not live here in America. We're not in an Islamic state. We're not in a place where once we pass away, that the distribution is going to go according to the Islamic law. It's not going to happen. If you think it's going to happen, it will not happen, even if you have heirs who insist upon the distribution to go that way, unless there's a universal and uniform agreement, which unfortunately doesn't always happen. Once there's something to pass on, people change their minds, and some of the most the kindest people with the best intentions, things happen, and some of their feelings change once someone has passed away. Next, what we have, Sheikh was talking about the wasiyah. So when we have the Islamic will that is prepared, there is the portion that's 1/3 that can be devised, and Imam had also described for all of us what that portion can cover. The wasiyah here, we say the definite command or obligation. So that for us is the portion that gives us or gives you some of the leeway to start to give some of those portions or properties regarding charities or charitable contributions. As the Imam had also, Sheikh Javid also mentioned too, with that wasiyah, that portion or that 1/3 portion can be used for certain outstanding obligations that you did not fulfill. But it is important to note that without them being written down, they have no effect. When we look at the goals of 2 types of wills, the secular will, we always, basically want to provide for your family, your decedents, and minimize some of the burdens on your decedents, and sometimes minimize some of the cost factor. The Islamic will, we do the same thing. But we have the other important step of is to prepare us for the transition to the hereafter, which is why it is so important that you do, of course, maintain a written record of your debts and a written record of your assets so that you can have all those things itemized when it's time to prepare the will. Now, many of the state wills that you'll see, most of the wills that are done in the United States, they don't list all the assets. Assets are typically not going to be itemized in the will. They will not be itemized, nor will any debts. So typically what you will have is that you will have a portion of the will that specifies specific bequests, certain things that are going to go to a daughter, a certain thing that's going to go to a son, my grandmother's ring, the China set. Those would be some specific bequests that you may see in terms of property. But for the most part, there is going to be a residual estate that is used and is also part of the estate itself that's going to be passed on to the heirs according to how you had determined who is to inherit. Now, one of the things that you always look forward to in the will itself is that you always talk about the domicile. Identify where someone's living. Make sure that's indicated in your will. The identity of the testator. Critically important. You may also see some things within a traditional will. You're going to revoke any prior wills or codicils. So as the Sheikh was talking about before, if you have the most recent will that you've written, that you're going to make sure that any other previous will that you've written it is noted within this current will that it's been nullified, it's been amended, it's been changed, and this new will is what's going to be commanding and what's going to take precedent. The appointment of fiduciaries. We see this other word here. The appointment of fiduciaries is important. You have to think about identifying for yourself who that person will be that will take care of your estate once you pass away. Now, it does not matter if this was a close friend, or if it's a close confidant, or if it was a relative that everyone knew that they would be the person to take over for your, in terms of your estate. If you don't have it identified within the will itself, there will be a deficiency in the will. So you would have, one of the terms you may use is the personal representative. There might be the executor. Those are the interchangeable names that you'll see within the will, and it's the components that you'll see in a traditional will. You may see funeral arrangements that are listed. There are provisions for paying debt. So the traditional wills will have a debt provision, typically even within state law. When a will is probated, the debts are going to be taken care of first, unless there has been an insufficient amount of assets in the estate. If that were to be the case, then there is a way for certain persons that are to inherit within the family to take, which is basically a statutory provision or a statutory share ahead of some of those creditors that may be present. You have, of course, your specific bequests, as we talked about, the payment of taxes, and then we have the residuary estate, which is what's left over. Now, and when we get to the part when we talk about the Islamic will itself that we are using now in the United States, it is this residuary estate where we have the inheritance provisions that take over. And sometimes there's a catch-all provision at the end of a will. If there's anything that's inconsistent, we want to remind any of those that will inherit that we have to fall back and take a look at the prescriptions and advisements that you have within the will. And that's what you see in the catch-all provision. Now, some of the fiduciary powers, and it's important to note too, you have the personal representative, which is the person who has power over your belongings. They can sue people on your behalf. They can step in the shoes of the estate to be sued. That person only has power and authority after our passing. If anyone has been assigned as a personal representative, in the will. It does not give them any power at all while living. So that has to be clear too. There's nothing that they can do with that. By the same token, there is an estate planning device that's called a power of attorney, a durable power of attorney, which is a device that's used to give some authority to one person or two people who can act on your behalf should you be in a situation where you become incompetent, where you can't act on your own behalf, take care of your medical affairs, take care of your financial affairs, take care of anything else that typically you would have done on your own. These durable powers of attorney are used typically in the state of Maryland. You have what are called springing powers, which means that upon a doctor or two doctors given a certification that you are not able to conduct your own affairs, that's when that person's authority steps in. But you want to remember one thing too, is that even the person with a durable power of attorney, I have had people come to me and they say, I have power of attorney over my mother. So I need to go and step in the shoes and start taking care of this estate. Well, I'm sorry, it doesn't work like that, because that only lasts while the person is living. You don't have, all that ceases. And that's one of the things that's important to understand within the will, the fiduciary powers, the administrative provisions, and the definitions of what those people can do. Sheikh Jabir talked about the trustee. Well, he talked about the living trust. Within a living trust, we'll talk about what happens in the living trust and who has some of those functions in terms of what they're responsible for doing. And of course, the signature and attestation clause, that's also important that you'll see in a regular will. These wills have to be signed. A witness to say, this is what I believe my father said he was going to do because I was standing there with him when he passed away. That's not going to work either. You have to have these signed and attested. And it should contain everything that you believe, everything that you want to happen when you pass away. You need to make sure that that is contained in there and that it is signed. Of course, in our wills, our Islamic wills, very similar in terms of them being in writing. We have different sources. The Quran gives us how the inheritance is to be spelled and how it's to be followed. There's no leeway in it. There's no thing that you can do as a testator to change that because it's already established. Now, being that we live in the United States, we do not live in a country that abides by Islamic law. You, as the testator, when I mean the testator, that means the person who's going to be writing the will or who's getting the will written for them, you have to define those within the will itself. If we see some of the same similar components of identification. Islamic wills may have a declaration of faith. There's ways that you can also giving dawah even towards the end of your life. You're giving indication of what you believe. It is important, especially for those of us who may not have a long history of Muslims within our families, those that are reverts, or those who live in families and they're basically a revert, even though their family members were born into Islam, that you are also letting them know that this is what you believe and this is how you intend to have your affairs taken care of. The declaration of liabilities and assets is important. You will not see this many times in your traditional will. So if you can, you start to remember and write down those things that are considered to be debts. As Sheikh Jabir talked about the three classifications of debt. And what is interesting in what he discussed was that the Class A and the Class B debts, and he can correct me if I'm wrong, but those are obligations to other people. And you see how important it is for us to take care of our obligations and our debts to other people. The Class A debt is one that is written down. The Class B debt, as he mentioned, is one that was stated at the time of death. And the Class C appears to be those debts or obligations that we forgot to fulfill for our own benefit that are taken care of and paid lastly. Similar situation, you always make sure you have the fiduciary. That's what we would have in our Islamic will. And parts of the estate bequeath to other specific and general bequests. Now, That is when we talk about the 1/3 portion. Now, Sheikh Javid mentioned the term wasiya, or the definite command or obligation. From the Islamic perspective, that's what we had some kind of discretion. That's our discretionary portions. Now, for some of us who have, I have seen this, for those may have family or people who cannot inherit from you. I mean, they are prohibited from inheriting from you Islamically. There may be ways that you can give to them within that 1/3 portion. Okay, but that means that they cannot inherit from you according to the Sharia. The Prophet sallallahu alaihi wasallam had mentioned that it's better for us to leave 1/4 than 1/3. I think that's one of the narrations, to leave more for inheritance to those who will come after you. Within that 1/3 provision, that wasiya provision that is often used, is where you donate to the charities, to the masjids, to specific causes. But once again, it is always important that these things are contained in writing. They have to be in writing. And these are some of basically the three main ayahs that reference, and the three verses that reference the inheritance specific details. It's in the book that we read, and we should be reading and looking at almost every day. It is there, contained in Surah An-Nisa. So you will see that this is where the heirship foundational rules are laid down for us. Also within the will, the rights and obligations of the fiduciaries, similar to the state or the secular wills. Now, the last part, signature and attestation. Extremely important. It has to be signed in the presence of 2 adult witnesses for it to be valid in the state. If you want your will, your Islamic will, to be valid and enforceable without having to introduce or have others give testimony in court or in a probate court to explain what you believe to be the wish of that relative, it has to be witnessed and it has to be signed. Okay. It is advisable that you have witnesses that will not inherit, those who would have no conflict of interest. That's important too, because what we do see is that when a person has passed away and the will is going through a probate process, it becomes contesting of what they believe, the person believed. Well, my father didn't believe in A, B, and C. And I think that my cousin who was taking care of him influenced him at the end of his life and made a change to what we believe to have been the proper way to have his estate administered. And that's why we have these independent witnesses. Both of these wills side by side. We can see, of course, some of the similarities, the secular will, quote unquote. And then, of course, the will that we intend to develop that will abide by the Islamic law, what it will include, some of the differences. You can include declarations of faith. You can exhort your descendants to do good. You can contain all those things in the preamble. It does not make it invalid. Some people think, well, look, the Islamic law has all these things about religion, or it has these things, these ayahs from the Quran, and I think that the judge is not going to honor us. I don't want that to be my will. No, don't. That's not the case. They will still abide by your wishes so long as it does not violate some of the state laws of inheritance in terms of who can inherit it when, rules against perpetuities. There's certain things a little more complex, but you can have all those things contained in your own will without having to feel that you're going to compromise. We have the emphasis on the heirship. Now, this is the complicated point. This is the complicated part. This is where you really need help. And there are programs, there are calculating methods that are used to help determine what it is, who is to inherit and what portion. this is where there's a test on you as an individual. Where you have a scenario where, you know, what you may want to happen is not what's best. It may not be what's best for you, and it may not be best for your family. And that's the test. That's a real serious test for you to make sure that you have the definitions and you have the predetermined amount in shares that are indicated in the will itself, because the probate court's not going to do that. They're just like, for the most part, most wills that go to probate, they're administrative probates, which means it's not going to have the court getting involved. It'll be the personal representative, and it'll have the heirs, and it'll have the creditors. Unless there's going to be a contesting, then the court gets involved. So you need to make sure that is defined clearly, and that you seek counsel with someone that understands how the heirship is to be written and how it's supposed to be spelled out within your wills. Once again, the attestation and signature, that is always important. Can you accomplish both with one will? Can you accomplish a will that meets our obligations, our belief standards as Muslims, and also be valid within state law? Yes, you can. There's no reason why you can't, and it's done all the time. Now, what Sheikh Javed had mentioned before was the differences between the will and the revocable living trusts. He kind of mentioned that. Now, people, what happens is that a revocable living trust is an estate planning device. So it is something that is used that can follow the same similar guidelines as the Islamic will, but there is a difference. And this is one of the major differences. The revocable living trust, the one major difference is that it does not go through the probate process. Anything that you have that is been funded into the trust will not go through probate. It takes it out of the probate process. And that's very important. The other thing that the revocable living trust does is for certain people who have family or friends that may question someone's competency. The revocable living trust, what it does is that it puts the power of the ownership of the trust into the individual tested or the person who's living. So they basically are managing their affairs, they're managing their property while they're living, and it's being, those items are funding this revocable living trust. The thing that you have to realize though with the revocable living trust is that it is of no use, it will not benefit you at all unless you fund it. And the question becomes, well, what do you mean by funding? Funding is a critical thing that you have to do. And that basically is telling you that you have to make sure that your property is going into the name of the trust. If you don't do that, then all you have is a piece of paper and everything's going to go right into probate. Now, when you have a revocable living trust, what is typically done by attorneys is that with that revocable living trust, you have a pour over will, which is like the catch-all, it's like the catcher's net. So you're going to have two. You're going to have the revocable living trust, and there will be another will. But that will is basically going to tell the heirs and the state that whatever that revocable living trust says, I'm doing the same thing. That's what the will is going to follow. It's going to follow the same guidelines, the same instructions as the other device. Now, do you need a revocable living trust or should you get a will? There becomes the question, right? So a revocable living trust is advisable for people who have assets in different states. Outstanding, because you will have ancillary probate. You have probate, let's say that you own property in Texas, you own property in New Jersey, there's property in Tennessee. The revocable living trust will be good because all those things will come into the trust and you won't have to file probate in Texas for one piece of property. You don't have to file it in Tennessee, okay? It'll all come under that one device. Most of us, if we have a good will, you'll be okay for the most part. A good, valid, and enforceable will do the trick. The other thing which was important that Sheikh Javid talked about is businesses. And sometimes you have business ownership, can my ownership, and it's an interesting thing because the Sharia, the law that he had described within Sharia, it's similar within the secular law too. You don't, you know, the business ownership, you don't you can't will partnership. You cannot will that to somebody else. You can have the interest, the financial interest in it, some of the shares, some of the things that need to be that are used to the benefit, but you cannot share the control. You cannot will control over the business, which is important to note too. Other than that, you know, I just wanted to give a basic component, some of the basic things you want to consider when you're getting the will done. Let me explain to you another thing. The living will, when someone says, I need a living will, that's not a will. A living will, what that is an end of life instruction. So living wills are typically end of life instructions that are given to family, that are given to anyone that's going to be caring for you. And that is basically in line with life-sustaining procedures. So whether or not if I'm on life support or if I'm in a condition where I can eat, but I can't breathe on my own, this is what I want to happen. And I think that's maybe another discussion that Sheikh Javid would get into, or someone other person would get into what you would do in that case. But that's not a last will and testament. That is called a living will. And right there, I think I'll end part of my discussion. If there are questions, we'll see if we can answer those questions, and we'll welcome any questions that you have.
Assalamu alaikum, Usama. So if everybody can direct the questions to Usama, then he can distribute the questions, inshallah.
Inshallah. Jazakallah khair, both Maulana Javed and Brother Ingram. You definitely laid down a lot of knowledge on us, both in the religious aspect as well as the legal aspect of inheritance. And with all that knowledge we attained, for those who didn't take notes, you don't need to worry. We have recorded this entire seminar on youtube.com/ICCL Live, our YouTube channel. It is being streamed live there. And it's also being recorded. So if you ever want to go back and listen, if you missed anything or you want to just listen again to something that you learned, because you may have forgot it, the name of the video is called Basics of Inheritance. So once again, you know, Brother Damani, you know, we're very fortunate to have a local Muslim lawyer here. I mean, in our community, we have several doctors and engineers and IT experts and businessmen, but we don't have that many lawyers. So I definitely request every one of you to take advantage of that. Brother Damani, his law firm does not only Islamic wills, they also provide services in many different areas of law. I encourage you all to go to his website, ingfirm.com. He is located in Columbia, Maryland, which is a neighboring city to Laurel, and his firm provides services in the Baltimore area and the DC area and everything in between. So that covers pretty much all of us. If anyone has a question, what I would like to recommend is that either you just click the raise hand option, or I see some people already doing this. You can place your questions in the chat box, and then I will go ahead and ask the question, whether it's to Maulana Javed or to Brother Ingram. Also, we have viewers on YouTube. Anyone that's listening on YouTube, you can also type in the question you have in the YouTube live chat box, and inshallah, we'll go ahead and ask them. We're already about close to an hour and a half in. We're going to try to take the questions and answer them as much as possible. Please, we ask that you limit your questions to something more brief. If you have more detailed questions, or you like, you know, Brother Damani as a lawyer to review anything, we ask that you contact his firm, contact him through the website ingfirm.com, inshallah, and you can follow up. And of course, we encourage all of you to contact him, inshallah, to set up a will or living trust, whatever you feel suitable. So I'm going to go through the questions in the chat. And once again, if you have other questions, raise your hand or put them in the chat. Before I forget, I have a quick question for Maulana Javed, if you allow me. You had mentioned pensions. Pensions are funded by the employer. So if someone pulled out that pension, it was to go into the inheritance pot. If they didn't, then it goes to the beneficiary. My question is for 401k. 401k is more of a mix between funds that come in from the employee as well as company match funds from the employer. So if someone did not pull out their 401k and they pass away, does all that money go into the inheritance? Does all that money go to the beneficiary? Or is it a mix between the two, depending on what was funded by the employee and what was funded by the employer?
Bismillah ar-Rahman ar-Rahim. So the question is regards to the 401k. It's similar to the pension fund, but if the employer has not mandated the 401k, so it's not mandated, it's something that you have opted into and you're paying the premiums and you're paying towards it, then you would be just entitled to your contribution technically, and the rest of the amount would be given to the poor and the needy. But if you would be only entitled to your premiums. If it is an obligation, meaning that you didn't have an opportunity to opt out of it. It's something that you're mandated, it's, this much amount is taken from your wage. It doesn't matter if you want it or not. So in that situation, the estate your contributions will form part of the estate, and the remainder of the amount will go to the beneficiary.
Okay, so for the first one, the entire amount goes into the estate.
Mm-hmm.
The second one is splits into two. Okay, we have our first question on the chat box. It looks like it's 3 questions, but we try to get through them quick. Number 1, for Maulana Javed, if a widow is receiving rent from her husband's property, how should it be distributed among all the children and herself?
So if the heirs have agreed to continue the rental on a property, so remember, it's not one man's choice, right? So if the heirs agree that their property is to be rented out after the demise of the person who's of the person who made the will, then then it will be distributed according to the shares of inheritance, according to the heir. So the wife would have 1/8, the son would have double the shares as the daughters. It would be rent would be distributed after expenses, meaning after expenses related to the rental property, it would be distributed accordingly. As far I have a suggestion in regards to that certain amounts should be kept in a separate fund that is for maintenance, and at the end of the year it can be distributed, or it can be disclosed to the heirs that this is how much we have in that fund, or in that COD, that this is how much money has been kept aside for the maintenance of the property, and everything else should be distributed according to the shares of the heirs.
Also, Maulana Javed, living mom has gold. How should the gold be distributed among all the children?
Say again.
If the living mom has gold, and then how should that gold be distributed among all the children? You have to put a dollar value or split up.
If it's going to be distributed after her demise, then it will be distributed according to the value of that time. They will just take it to the jewelers. They will give a value on it, and they will it will be distributed amongst the heirs according to their shares. There is other ways of distributing it. Again, it's because remember, it's not just gold that a person has, is it? Gold is just part of the entire estate. So what happens is the entire estate will be, we will take an account of the entire estate, and then we will distribute accordingly. Somebody might just get all the entire amount of gold that will be their share. So, but if you just wanted to distribute the gold after the one's demise, it will be distributed according to the Sharia set standards of shares. But if you wanted to distribute the gold prior to one's demise, then it will be distributed equally in amount, in the equal amounts.
So that would have to be distributed equally. A mother can't. I think that's what the individual was mentioning with this question, that the mother can't decide, I want to give, if while she's alive, I want to give this person more and this person less.
No, she can't, because remember, even though that type of gifting will be allowed in Islam, but it's not recommended, nor is it permissible to deny somebody their right. If you want to give something in your lifetime, it should be equal. That's what
Sons and daughters.
Sons and daughters will receive equal amounts. Right. That's the ruling. Obviously, if somebody goes against the ruling and somebody gave one daughter more than the other daughter, even though that gifting would be permissible, it will go into their ownership, but they've still done something wrong.
Okay. Brother Damani, the same individual mentioned that they actually completed their will with you in 2019 with the Ingram firm, and they're asking, does it need any update as their financial condition or property status has changed, or is their will fine as is? Because I'm assuming it's set up with percentages rather than the amount of financial ownership.
Yeah, I mean, theirs is set up. It's set up with the percentages. Now, in terms of them trying to identify the additional assets that they've accumulated, or to have a section to add as an addendum, yes, we should talk about that. You're certainly going to need to amend or change your wills when it comes to the heirs. If someone has passed away, or someone has you've not necessarily passed away, have more children. That happens a lot. And so there's always the best time to make those amendments and changes, and also just to take a look at too. Sometimes, even within our wills themselves, there are sometimes that we can have take advantage of some of the tax advantages that are contained in our states, depending upon the value of our assets. That might be something that is considered. So I'd just let her know. Definitely give us a call, and we can sit down and see if that's something that needs to be explored.
Sure. And brother, do you have an estimated cost for creating a will or a living trust, just so that the viewers know?
Well, I mean, that's another question. And I didn't mention this during the presentation, but folks must understand too, the brothers and sisters must understand that you have to have a separate will for each person. Some folks that feel that I have a will for me and my wife. That's not going to work. It has to be one for you, and there's one for her. So you all have your own separate estate planning documents. Depending upon the will, that things can go from a few $100s to a few $1,000s. It depends upon the person's assets. It depends upon how much, what they want to contain inside their estate planning documents. We always recommend that people have not only the will, but they have a durable power of attorney, that they also have healthcare directives. Those of us who want to have revocable living trusts, those are typically more expensive. If you have any kinds of tax planning that have to be included in those, and that's something also that has to be considered. But we do say that we do offer
approximate.
What's that?
What's the approximate cost about?
Yeah, approximate cost for a will and estate plan is about $1,200 to $1,500. That's for entire estate plan, for basic estate plan.
I think that's what people needed to hear. That.
Yeah. So that's typically for an entire estate plan.
And what about ICCLs and a discount?
Yes, ICCL discount. I need to give an ICCL discount code so everyone knows. Absolutely.
Inshallah.
But we do offer free consultations too. So we want to see some things, folks have something extremely similar, something very simple, and it won't be as costly.
Jazakallah. And someone also asked that you mentioned wills must be signed with one witness. In Maryland, is notary needed also or not?
Now, I want to make that correction. Not one witness, two witnesses. So there has to be two witnesses, and it does not have to be notarized.
Okay.
So you have to make sure that these are two witnesses, and for our purposes, we know that as Muslims we have we know when we can define a person to be an adult as Muslims, reaching the age of puberty and so forth. But here in the state, they got to be 18. So you want to make sure that it is signed in the presence of the two witnesses. And I mean, I have to stress that, in that presence. Now, recently, within the last 2 years, since the COVID time, there has been a way that you can have the remote signing of a will, remote witnessing of wills. But it's a whole code. There's a whole section within the annotated code that explains what has to be done to have that kind of remote signing, remote witnessing. And it's really much easier to make sure that those people are in the presence of the testator when this will is being signed. But it does not have to be notarized.
We have two people that have their hands raised, so we're going to go to their questions and then we'll go back to the chat questions. I'll unmute you, starting with Nadine. Go ahead with your question, please.
Hello.
Yes.
Assalamu alaikum wa rahmatullahi wa barakatuh. And first, I would like to thank Maulana Javed for giving excellent presentation about for the common man like me to understand the inheritance laws, and also for Mr. Damani for his time to share with us his legal expertise. The first question is that I'm impressed, and I'm Rukunuddin. Okay, I live in this community for a long time, and I'm a professional and work in some kind of things. Okay, and I'm not a businessman. Okay, that's what I just wanted to say. And if I have to contact Mr. Damani for my legal help, and would he like to share his email or the cell phone so that I can directly contact him rather than contacting through his organization? That is the first question.
Yeah, the best way to reach me, honestly, is that we have an email address that all the direct intake comes to, and it's really because I get a lot of email, alhamdulillah, but I have a very organized intake and contact system that allows you to contact us 24 hours a day, 7 days a week. And I did have it on one part of the presentation, but I will put the contact phone number and the contact email address. I'll give you my email address, but there's another email address that makes sure that you'll make sure that you get your questions addressed. If you want to make an appointment, they will set it up, and they're pretty good in that follow-up. Okay, brother. So I will put that in there. Maybe if I can type it up in a few minutes, you guys can get it and you can share it to everyone within the group.
Hey, brother, if you could type it into the chat for everyone, then inshallah they'll have it. If you're comfortable doing that.
Sure, I'll do that right now.
Okay, and the second question is, your law firm, I just browsed it through the web, and anything connected with the real estate?
What's that, sir?
Listed in the web.
You had a question about real estate?
Yes.
Okay. Yes.
Real estate law.
Yeah. So our firm, it's very limited real estate practice, very limited that our associates do. So what I would advise, if you have a real estate issue, you should contact us. And what I tell folks too is that we don't claim to do everything, and we don't want to do all kinds of law. But what we can provide you is a resource and a place to contact if you're not sure about something, to make sure that if we can't help you, we can direct you to someone that we trust, someone that we think can help you answer those legal needs. So okay. I put the phone number there to reach out.
No, it's not here. I cannot see it.
Oh, I think I put it as a direct message. That was my error. Let me put it to the
Yeah,
entire
you put it directly to
chat group. Yeah, I actually put it to you, Say, by accident.
everyone.
Yeah.
Yes, please.
So I'll do that again and put it to everyone. But you can give us a call, and I encourage anyone to call if they have any kinds of those types of legal questions, but don't shy away from calling. If
Sure.
it's
Yeah, it's not very complicated, I believe. So even the very elementary level, I would say, with reference to that. Okay. Okay, we got the number. Is that true that it is 410-992-6603?
You got it.
Okay. And 410.
So I'll give you my direct email and also the email that'll reach any person in my firm, thecleo@ingfirm.com. I would also, anyone from the seminar, I advise you to make sure if you're sending something to me directly, that you do CC that Cleo@ING email address too.
Thank you, Brother Ingram. The next question looks like from my mother who's on. I'll just ask her to unmute.
Marine?
If you can click mute to unmute yourself, and then you can ask the question.
So I think it's Sister Marine.
Yeah. So while she's doing that, I will ask another quick question. Somebody asked, does your firm consult scholars in this process? With the different madhabs, there might be different rulings. So how's that addressed?
Yeah, so no, we do for issues that things that we cannot answer. We do consult scholars, and we do consult individuals that we can derive advice from. So that is done.
So I just have an add-on to that. Did you know the best way to address that is for them that if they want a certain ruling according to a certain madhab, maybe they can just ask the law firm to do that. That way then they know exactly what to, who to contact. Otherwise it would be difficult for the law firm to determine which madhab they actually want to, the ruling by.
Very, very well. Exactly. Thank you, Sheikh Javid. So you would definitely help us to help you, so that we can connect you to the right person.
Okay. I just spoke to my mother directly. Her question was, I guess, from Milana Javed, if someone passes away with a student loan, is that loan forgiven? I believe, according to our local law, if anyone passes away with a loan, they still owe that money. But I think there's an exception to student loan.
Right. So if a person passes away with a student loan, and there is some kind of an agreement between the two parties that if somebody passes, if the person that has taken the loan passes away, then the loan will be forgiven. Then we will say that the creditor has forgiven the loan, which is fine.
Jazakallah. Another question in the chat, Milana, is it allowed for a father to say that I spent a lot for my daughter's marriage, so she will no longer have any share in the inheritance?
Absolutely not.
Jazakallah.
Yeah, absolutely not. The two are not related.
Right. Next question. When my aunt was still alive, she had two daughters, and she made it clear that she had little she had goes to her youngest, the little she had goes to her youngest daughter because she doesn't have a father. But both of her daughters agreed. Sounds like maybe the older daughter had a father, the younger one didn't. The eldest sister later had a son, and a few years later passed away. 2 years later, my aunt passed away. Does my cousin need to split what little she has with the eldest daughter's child?
So there's two questions within a question here, it seems. The first question is that the youngest daughter, she wanted to give whatever she had to the youngest daughter, and the two eldest to agree. It doesn't work like that. It doesn't work like that. That's not how Islamic inheritance works. The it has to, the ownership has to transfer, and then her wishes can still be pointed out in her will, that she wishes that everything be given to the, but then it's up to the two eldest daughters once they receive ownership of the assets if they wish to give it to her.
Right.
That's
And
number
well,
one.
yeah, and I think you answered the second question, that if the eldest sister passes away and then her mother passes away 2 years later, does the eldest sister's son, is the eldest sister's son entitled to any inheritance? And I believe you mentioned that they're not.
They're not, but you could make them part of the wasiyah.
Right, because they're not heirs.
Right. So they could, so like, for example, if I had an adopted child, some people ask this about adopted children. Adopted children do not form part, are not the heirs. So adopted children would receive a share from the wasiyah. And so grandchildren whose parents have passed away can get part, that they become heirs part of the wasiyah. That's not a problem. You can still see there is still contingency there for people you want to give to, even though they might not be your heirs.
Mommy, how do you put this in here?
Come here.
Oh, and I can add to that also, and just from the perspective of honoring someone's wishes, that's not written down. So that's another thing too. Beside the fact that this may be prohibitive according to the Sharia, you also have to remember too, anything that you want someone else to enforce, it has to be in writing and has to be witnessed.
Right. So speaking on that, there was a question, what if the two witnesses pass away before your will is executed? Is that fine? Or do you need new witnesses if someone passes away? If one of your two witnesses pass away, maybe Milana's a question for you, or also from a legal perspective, also Brother Damani. So from a religious and a legal perspective, if I write my will and I have two witnesses on there, one of them passes away, do I need to get a new witness to sign it? Or is it fine that the witness is no longer there when I pass away?
I'll let Sheikh Javed answer first from an Islamic perspective. If there can be an answer, and then
So if the witnesses pass away and the heirs honor the document, then we wouldn't have a problem. If they contest the document, then it will go to the qadi, it will go to the judge. And then obviously the judge will determine what to do from that point onwards.
So it's better to get a new witness that.
I mean, yeah, if you feel that it's going to be contested. But again, if if you can't bring up the witnesses to actually verify then maybe a notary would have benefited at that time. That, the notary, again, if the notary would, then it just continues. What if the notary passes away? So it is going to hold weight, right? It is going to hold weight. And you can even get notaries authenticated. So by the state can authenticate notaries also. And the Department of State can authenticate the state. So there's ways of authentication there. It depends how many layers you want to put in there. But if there is a dispute, then obviously it's going to go to the qadi, it's going to go to arbitration. But again, if it's Islamic law that you're following, then you don't really have a problem. Yes, brother, the money. What does?
Oh yeah. So, and actually, what Sheikh Javed just mentioned, that it would be very similar in the state court too. So long as there's not a contesting to the validity of the will, then there's not an issue. Now, when someone says, "Can I get a new witness?" you don't just get a new witness to an old will. You have to write a new will. So you basically have to amend it, and it would take the new will would supersede the previous will. If that was the concern, you're getting new witnesses. That's essentially what would happen.
That's good.
And I guess the other point too, which is good too to note, is that when you have your witnesses, it is good to put down, if you can, put down the address of the witness they sign, but also print out the name too, so we can discern who that person is. And if we needed to contact them, or if there's relatives regarding that person's capacity later, it's easier to do so.
Right. Just see two more questions. One is, does your firm help in writing the will, revocable living trust, and what is the average fee for the service? I think you answered that. Yes, you got it.
Yeah, I did answer the question. Yeah, like I said, it ranges from a few $100s, depending upon the estate device that you want, to a few thousand. Now, what I wanted to stress again, and whether or not you use me or any other firm or any other person or platform, is that each person has to have their own estate planning devices. So each individual has their own set of estate planning documents. And we do generate revocable living trust and last wills and testaments. Yes, ma'am. Sheikh?
Do you know, I think that if a person has an executor of the will, and if the executor is either an Islamic institute or a law firm, which both is acceptable, it saves that even if the witnesses were to pass away, because the law firm was had that document with them for that amount of time, they would have verified everything before they became the executors of that will. It would be, again, a difficult one to challenge, even if it does go to court, because it's been with the law firm for such a long period of time. They had already verified all the information, even though those people who were around at that time are no longer living. But it did go through that. The scrutiny was done at the time, and there will be some document proving that. So it will help.
Yeah, and that does help to have the law firm involved in the process, signing it in the presence of the attorneys that are at their firm, and them also maintaining the document. So that alleviates some of the challenging issues that you have, like the scenario that you just mentioned with the daughter and the promise to the little one and those things. That becomes a major issue when you don't have something in writing. Aside from the fact that it may be prohibitive Islamically speaking, but even if it were to be permissible, it would not be enforceable because you don't have any of those things in writing. You would have a contesting, and you'd have competing interests and competing testimony amongst all the people.
And the last question is also really directed to both of you. It's regarding web pages. Someone asked about how about Sharia Wiz web page, and one brother also posted earlier a web page from ilmsummit.org. These are web pages where you can go in and you can enter in your assets, and it will calculate and you enter in how many sons you have and daughters, and whether your mother and father are alive, and brothers and so on. It'll calculate who goes to what and how much. What is your feedback regarding using these web pages? If you have
basic shares, sons, daughters, very basic, then it's fine. They're probably be able to give, but still you need to verify the answers with your local mufti, whoever is there. But sometimes the situation is not as straightforward, and you're going to have to get somebody more knowledgeable involved. So as far as just like the distribution of shares, it can help, but then the distribution of shares is just a part of the entire estate and what goes into a will and what goes into a living trust. So the distribution of shares is sometimes it can be complicated, but most of the time it's not. But again, the distribution of the shares is not just the criterion of the will.
Brother Damani, do you have any experience with people using these web pages and then coming to you afterwards? Is there ever any discrepancies between your firm and what they get?
Well, I mean, what I would say, I am familiar with one of the websites in terms of calculating the distribution percentages. The other website, the Sharia Wiz, is one that's basically offering the service to generate the will and the estate plan. Not to take any business from anyone, because that's not what I'm in the business of doing. but you also always have to be certain that whatever's being generated by an organization that's outside of your state, that whatever it contains, it's not violative or it's not prohibitive of any of the state law that you, for the place where the will be executed or where it would be administered. So those things are always important to note, to note the differences. So I'd always advise folks that when you do use any of these types of organizations, I had a client that came by earlier this week who used a service that generated self-generated. You put in your information, your numbers, and you kick stuff out to you. And he had a number of documents, multiple pages of boilerplate information, but he missed certain things in his execution of the document. It was missing things that would render the entire document invalid in the state where he lived. So it's always important to seek that legal assistance if you can when you are going to get any of your estate planning documents developed, and then using one of these services too. You just want to make sure you can get that reviewed if possible, or use something else.
Right.
Okay, inshallah.
Jazakallah khair. Very, very excellent program. We've used up a whole 2 hours. For anyone who's not present, I would definitely recommend that you ask your family members and friends to go back and watch this program on YouTube. It's very important information for all of us. Many of us just keep thinking we would prolong this and do this when we get older, but we, like mentioned before, we never know when death will come, so we should all be prepared. Inshallah. Malana, if you can just complete with a quick dua for us.
Subhanallah wa bihamdihi, subhanallah al-azim, subhanallah walhamdulillahi wa la ilaha illallah wallahu akbar, wa la hawla wa la quwwata illa billahi al-aliyyil azim. ربنا تقبل منا إنك أنت السميع العليم وتب علينا إنك أنت التواب الرحيم برحمتك يا أرحم الراحمين. جزاك الله خيرا. السلام عليكم ورحمة الله وبركاته.
وعليكم السلام ورحمة الله.